What happens if you die without a will? This is something that affects everyone, yet many people either misunderstand it or ignore it. As an estate planning lawyer, I've helped hundreds of families plan for what happens when they die. By the end of this video, you'll understand what happens if you die without a will and how to make sure your choices are honored and followed. First, let's talk about what happens if you die without a will. Legally, this is known as dying intestate. When you die intestate, the government, more specifically the state government where you live, steps in and takes control. This is through a process known as probate. The government will distribute your assets according to a set of laws in the state you were in when you died, and also the laws of any state where you own real estate. Without a will, you lose control over your assets. The state laws may not reflect your personal wishes. As Benjamin Franklin said, by failing to prepare, you are preparing to fail. So what are the potential consequences for your family? Dying without a will can create significant problems for your loved ones. Without clear instructions, disputes can arise over who should inherit your assets. This can lead to strained relationships and even longer legal battles. For example, consider John, who died suddenly without a will. His 3 children, once close, ended up in a bitter dispute over his estate. The state's laws divided the assets equally, but one child felt that they deserved more due to their role caring for John. This led to a costly legal battle and damaged family bonds. A study by AARP found that nearly 60% of Americans don't have a will. This statistic highlights how widespread this issue is and the potential for family conflict without clear, legally binding instructions. Next, the impact on minor children. If you have minor children, the stakes are even higher. Without a will, the court decides who becomes their guardian. The judge's decision might not align with your wishes or be in the best interest of your children. Consider Susan and Tom, who died in a car accident, leaving 2 young children behind. Without a will, the court appointed a guardian based on the state's laws, ignoring the couple's preferences for Susan's sister, who lived out of state. The children were placed with a distant relative they barely knew, leading to a challenging adjustment period. Next, financial implications. Dying without a will can also have a significant financial implication. The process of settling an estate intestate is costly and time-consuming, resulting in higher legal fees and administrative costs, reducing the overall value of your estate. According to the American Bar Association, the probate process for an intestate estate can be lengthy and expensive. Executors may need to post a bond, notify potential heirs, obtain court approval for various actions, all of which can delay the distribution of assets and increase costs. On average, the cost of probate across the country is between 5 to 9% of the estate value and takes between 9 months and 2 years. Next, distribution of assets. Another critical aspect of dying without a will is the distribution of assets. State intestate laws prioritize certain relatives, but they don't account for the nuances of individual relationships. For instance, if you're unmarried but have a long-term partner, that partner might receive nothing if you die without a will. Consider Emily, who lived with her partner Mike for over 20 years. They never married but shared a home and built a life together. When Emily passed away without a will, Mike received nothing from her estate because state law prioritized Emily's estranged siblings. Mike was forced to move out of the home they had shared and struggled to make ends meet. Next, a will allows you to address special circumstances and personal wishes that intestate laws cannot accommodate. For example, if you want to leave a specific heirloom to a close friend or donate a portion of your estate to charity, these wishes won't be honored without a will. Finally, the importance of estate planning. Estate planning is not just for the wealthy, it's essential for everyone. Creating an estate plan that ensures your wishes are honored, your loved ones are cared for, and your assets are distributed according to your preferences. In conclusion, dying without a will can have far-reaching consequences for your family, your finances, and your legacy. Intestate succession laws might not align with your wishes, leading to family disputes, financial burdens, and unintended distributions of your assets. If you follow me on social media, you know that I also share a lot of information about the benefits of a revocable living trust over a will. That's why your next step is to watch my video linked here on a will versus a living trust.